Dear friends, in the continuation of our video, I'm talking more about the NCL80 Chennai bench that represents the South India interest of the South Indian litigants. Actually, I filed one bill before the Honorable Madras High Court. There was an appeal for me at that point in time. I went to Delhi and a lot of people are there, but then even to file a case, get it listed, we have to pay 25,000. Then you have to go by plane and come back, and the case may be heard, may not be heard. Justice Mukhopadhyaya was the lordship in charge. So I realized it is such a difficult thing. And then I thought, many people told me, senior counsels, no, we cannot, it is not worth going to appeal. It is costly, time waste and all. So then I thought, why don't we try? I'm a small advocate, only resolution professional working there, doing some work. So, but then I thought, in the larger interest of the nation or the South Indians, first step is, if it is Supreme Court, you can online filing is the best. Even we are trying to bring it into Chennai. There is no need for the clerical staff to call you, trouble you and all. And if you know how to prepare your petition, SLP and all in Supreme Court by online, I think that day itself your case will be numbered. Diary number will be given, then thereafter this. So we are trying our best. It is in interest of this. So I'm not beneficiary at all. So, but then luckily that bill had an impact, and simultaneously the judgment also has come from the Honorable Supreme Court to constitute the circuit benches. So both matched, and maybe the seniors in Chennai also would have persuaded Justice Mukhopadhyaya and others. So I don't want to say it is because of me and all, but it's instrumental to it. Mr. Arvind Pandian was actively involved in this, to my knowledge. Thereafter, the constitution took place, NCLT bench came, but it's idling because Justice Bhatt, who was the chairperson then, he passed an order saying that this order will come to effect for the new cases filed, not to the old ones. Because again, you would have seen that power of the lawyers at Delhi would have got influenced. So I filed one more bill. That Chief Justice Sanjeev Banerjee was there. When he saw it, he said whether Delhi is India. He asked the question, and in the next hearing they transferred it. That was a real good achievement. You can see this is the order of that. Since the counter affidavit apparently filed on behalf of the union is not immediately available, let the matter appear 1 week after the summer vacation, 21. It is submitted on behalf of the union that because of constraints of space where the Chennai bench of the NCL80 is to function and COVID-related problems, a temporary order has been made for new matters only to be taken up by the NCL80 Chennai. It is hoped that the 350 matters which otherwise ought to be taken up by Chennai bench will be made ready for transportation before the matter is taken up next upon the COVID situation improving. As to the constraints of space, every effort should be made to start with digitalization as soon as possible so that minimum amount of hard copy is required to be preserved. And the preservation would be only in the form of digital records which metadata links. There is already an advanced system of digitization which has been embarked upon this court. If necessary, the Chennai bench of NCL may replicate the same so that preservation of the papers after the completion of the matter may not be necessary. In any event, since the bench is at its nascent stage, mode of e-filing and paperless form adjudication should be actively pursued. So that matter was solved. And some effort you make it, then it helps the fraternity. And today it is very, very good. You can file in no time. IA is filed within 3 days. It's numbered. The matter comes. You go physically appear and all. Then we had one more problem, that is the benches are not functioning. That's particularly for NCLT. And NCLAT now only second bench has come, but that is not operational. So we are thinking of filing one more bill to have one more Chennai bench. And there is everybody says that bill, if you file, the present Honorable Chief Justice doesn't like and imposes costs. And therefore we are all scared. So let us see. I'll go directly to Supreme Court. That's the best thing for me, I was thinking. But then I'm filing it by 2 months from now. And this is infrastructure is already made ready in 2018 and fill up all vacant posts of adjudicating authorities in Honorable NCLT we filed. Then that will apply to NCLAT also. So I filed that petition. And finally, they agreed. And they say, in view of the above, the writ petition has become infructuous. However, we leave it open to the petitioner to pursue the matter with regard to third bench of the National Company Law Tribunal at Chennai in due course of time, keeping in mind the pendency of cases. So when you want to file a bill, friends, you have to collect a lot of data. And here the problem really is a judge is asked to take 60 to 70 cases. And in one case, there will be 5-6 cases, IAS will be there. And so the burden is too much for the judges. You can't hear. Then suppose one judge doesn't come, the same judge will have to sit in the next special benches. So this matter needs to be addressed. And recently one person criticized the judiciary, some government top official, wherein he said that it is because of the judiciary excellent legislators are failing. But actually it's the other way around. It is the Ministry of Corporate Affairs which is the culprit. So we will have to take up that matter. Now, some issues of adjudication, dear friends, I would like to speak. Before that, when you are appointing, when MCA appoints, there is a rule that NCLAT should have only retired justice of high courts. And you can say even Justice Abhay Oak in Supreme Court, while he's delivering lecture, he said that I try to specialize in insolvency. I had to read a lot because very specialized and highly technical subject like that. So a High Court judge, no doubt, his competence is the best. But then, can you compare with a judge who retires and applies for the NCLAT post? And then compare with a distinguished member of NCLT who worked for 4 years, who will be comparatively fast. Therefore, the blanket decision that only High Court judges have to be appointed as judicial members or otherwise. But then technical members also are taken from IAS cadre and other things. They take a lot of time to understand. So why don't the best performing members of NCLT, either judicial or technical, be elevated to the first priority should be given. This acts as an incentive. And in this connection, we have filed one Supreme Court, one petition. For the simple reason, two main issues. A member who accepts is from Delhi. Now you put him in Chennai. Actually, there is a feeling people think that these are all the appointment judges are waiting. These members are of distinguished character, lot of knowledge, and their accepting the job is very, very good for the nation, for the NCLT, NCLAT. That is Justice Jain just retired, we have seen. And the Honorable Chairperson, Supreme Court judge, took up this job. What a contribution he has done. Excellent judge. Therefore, their 62 is very young age now. Up to 70 or 75, there is nothing wrong, provided the member is of good energy, enthusiasm established. In this connection, many senior counsel, they see, I'm not telling my opinions, I talked to a lot of seniors and all before making an article, and then put their points. Of course, I am in concurrence with that. If you take the Honorable NCLT Chennai benches, Jain sir is the senior most person, and he is excellent. He will. There is a protocol, procedural protocol. Only first petitioner will speak. He will allow. Whether you are a junior most person or senior most person, petitioner should present his case. And in the arguments, you have to come prepared. He is very quick in understanding, but he'll give you full time. He will not disturb you when you are speaking, unless you are going errata and all. He listens. That is really good thing I've seen. And in a final hearing cases and all, first step is hearance. Second is being a judge from the experienced district judge and other CBI and registry of Supreme Court. And his sharpness is quick and he follows procedures. I saw many judgments. You argue everything, that's fine, but the way in which the judgments are delivered based on the material available and all, excellent. In some judgments, I myself felt that I did not know that I'm arguing these matters. And of course, he is ably supported by this Honorable Venkatraman sir, very knowledgeable. A CGM retired from SBI. But we are thinking, instead of going on taking some new persons and then these things, proven judges, kindness, unbiased, certainty of law, and then why are you searching? Then their dispensation will be much, much faster and justice will be done. See, when the orders are passed, it's not necessary what you want will happen because the three-layered system is there. But then the judges are of commitment, sincere judges are there. So therefore, this now it will be another 2 benches are going to come. And in NCLAT, Chennai bench, second bench gets started because my bill is there. Then naturally they have to recruit. And this is a very important thing that MCA or the ministry, finance minister must consider. Now, let me read out about the honorable member. Born in 63, 70 years means 2033. So therefore, it is a greatest advantage for the NCLAT adjudicating mechanism. And because when new High Court judges come as judicial members, then these people can help them much better in analyzing the situation. He joined the DDA as an engineer, Delhi Development Authority, and he's an engineer, he's technical knowledge, and worked in a multi-story building project. He did his LLB from Delhi University and LLM from Kurukshetra. He joined Delhi Judicial Services on 2/11/92, was promoted Delhi Higher Judicial Services and Metropolitan Magistrate Civil Judge. And you see the specializations of thing extraordinary good. And Section 65 petition was argued before him. His knowledge was fantastic on the, Section 65 is basically initiation of Section 7 by fraudulent means. And only judge with that capacity can understand whether fraud would have taken place or not. As a special judge, he decided bank fraud and disproportionate arrest cases and a case of politician involving an illegal possession of helicopter. See, such a politician means you would have faced terrific pressure. Narcotic cases, arbitration, and all, massive knowledge. So therefore, we'll start this with this request. And now before that, let's go recap how this adjudication is taking place in the NCLT. So far as our NCLT Chennai bench is tough judges, you can't act funny with them. Whatever pressure may be, they will be able to handle it. Now, Honorable NCLAT, we are trying to understand the functioning. Just to recap, 7 years of since inception, and the jurisprudence contribution, the judges and the Honorable Supreme Court has passed certain strictures also against the judges of NCLAT. Honorable NCLAT is an appellate body for matters concerning the Insolvency and Bankruptcy Code, which is the most significant economic legislation impacting the economy. It deals with banking loans and industries, both large and small, that face financial distress due to mismanagement and require revival. Honorable Tribunal is manned by judicial and technical members who hear the matters under the Companies Act and IBC. These matters are argued by senior counsels charging. This is one problem. The topmost counsels, 5 to 10 lakhs per hearing, they will come and argue, and you have to give respect. Lot of time they will take, and the judge should have control to conduct the affairs. Otherwise, these people will take you for a ride. NCLT, the exercise is the original jurisdiction, friends, constitutes the most crucial link in the three-layered system, and NCLAT and Honorable Supreme Court. Section 61 and 62 of IBC provides for statutory framework of appeals. But here one thing, dear friends, why I am taking up NCLAT is that NCLT is original jurisdiction. This is overloaded with cases, and the judges have to sit and do it. And if you go to Supreme Court, the case is very difficult admission. Though you have a statutory appeal rights, and within minutes they will dismiss like that. No reasons are attributed. That's all that. I was appearing in one case. 9 is one person's case. 10 is a person known to me's case. 11. Then Honorable Justice Chandrachud, 9 he took up. Then he said 11. Then that 10 man said, "Sir, Lords, my case is not, it's dismissed," that officer told. That means without hearing it is dismissed. Statutory appeal. And then my case came, then I didn't leave it. The same thing they want to tell. No, why you come like this? Then I said, no, my case is this. Then judge was, no. Then I explained them, if your lordships are going to pass an order, it is going to be wrong. And that is, we are challenging the constitutional validity of section 204. And then judge, I told the judge, Lordship, you have made up your mind to dismiss my case, no problem. But at least the order should not be wrong. And let me correct your Lordship. He agreed. That's no issue. Same thing happened in before Khanna, Justice Khanna bench. And they will not listen to you. If you talk little more, they'll impose cost. But my case came in Abhay Oak. I didn't speak. He only argued to the IDBI Bank and allowed the petition. But he is well prepared, extremely knowledgeable person. So it all depends, chance. But NCLAT, they will hear it. And very rarely you find, we'll discuss about the NCLAT issues. As a matter of practice, most appeals before Honorable Supreme Court are dismissed at the admission stage. Even when admitted, such appeals often take years. Suppose Justice Abhay Oak was telling me, Mr. Shivkumar, your case admitted. You didn't ask for stay, so we didn't grant it. But now you are asking to be listed. Anyway, we are listing for you, being a party in person. But then, on merits, it will take 2-3 years. That's what he said. Honorable NCLAT occupies a unique and important position in the judicial system with the technical and all. Recent reports indicate stable face. Now, we are going to take the problems faced by the NCLT members, which is proven. As you know, I filed, I just discussed about this, the bill I filed. Thereafter, the other things which I have explained to you. Now, one more point I want to raise, friends. Honorable Justice Ashok Bhushan, sir, very knowledgeable, very kind, and you will feel comfortably. Let it be dismissed your case if it is not right. But if Lordship agrees to continue till July 6th, when he reaches 70 years, it will do immense good for the administration of NCLAT as well as the adjudication of NCLAT. Now, Sharad Kumar Sharma sir has come. We need to discuss about him now. And Honorable Justice Desai is elevated from Madras High Court. Very good, very energetic and handsome person. And comes with well prepared with a lot of interest. And he plays cricket or something, athletic type person, gentleman judge. and his knowledge on the civil procedure code is extremely good, full command. He rose from the district judge level, and he's a votary of natural justice. In one of the cases, I saw that I engaged one lawyer, and when I came as a part in person, he asked me, "You engaged a lawyer, how can you appear? You have to correct that procedure. Let that lawyer agree to withdraw, then I will hear you." That is the extent of procedural things. Without hearing the other side, he will not pass orders. Even there was an interim stay. He said, "No, I have to hear the other side." It is not only for me, it is for everybody in Madras High Court it does. And a good judge, very good judge, pleasant judge. I think a lot we can expect from his judge. Now, this is what we have said already. We'll see that judges are facing top pressures, we have seen. And you see here, this is about Justice Sharma. We have seen he is in the news several times. One case, he recused in a case where his brother tried to influence his own brother, and he made it public. In another case, now Supreme Court ordered an inquiry. Senior most of Madras High Court judge wanted him to pass an order in that particular manner. He made public and then recused. It needs a lot of courage, dear friends. The learned judge is one of the iconic judges, in my opinion, a very bold judge. Perfect. He comes well prepared, highly energetic, but he sticks to his rules and regulations. Real judge, and he doesn't care. Dharma, justice is his weapon. That's all, nothing else. He doesn't see anybody else. Lord Shiva like that. In this case, if you see, this is a case where the stay was granted. Justice Venugopal sir is there. He has a different approach. For somebody he likes, he will give stay. If he doesn't like, he will not give stay. What he says, he will not apply it to the other cases. That is the extent. 5 years. And the Lordship was always talks about cricket match, films, and incidentally, when the lawyer is arguing, suddenly he'll say, "Tendulkar has acted like this, and you are doing like this, like that." The judge flow will be, the lawyer's flow will be cut. Suddenly he'll pass comments. And on that day, this case came. My case also was there. What happened? Condonation delay was there. Without condoning the delay, he gave a stay with on merits. And this lordship said, the president, this is a case where Mr. Anil Kumar was indulging in heavy corruption. And paper reports, you all know that cash is taking to pass the orders like that. But then that things have went on there. He came before him, another case of Anil Kumar. See, he ordered an inquiry. President NCLT is required to look into the issue and conduct an inquiry, particularly in order to attach fairness to the proceedings of NCLT, so as to repose confidence on the public at large on these matters. It is hoped and trusted as soon as the aforesaid process is complete, the Honorable President is requested to furnish the report back for necessary further action. So we can always file a bill, but who will file? The problem in this NCLT is the judge sits for 4 years and the lawyer has to appear before him. If you are against that judge, then your stories end. That means 4 years you have to sit in the house. And every client comes to you saying that, "Will you get a favorable order for me?" That is how it is, Madras High Court. I mean, this is happening. And if you see here, this is the case. Justice Venugopal sir allowed, this is, in the absence there being condonation of delay in preferring the appeal itself is not mature to be heard on merits for the admission. For the opposite, he dismissed that, vacated the stay, dismissed the condonation, finished the matter. That needs courage. Because this all happens, who will tell? And it happened too much in the case of Justice Venugopal sir. Because you are arguing something, suddenly he'll talk about cricket match. Suddenly he'll talk about Shakespeare, suddenly civil procedure code, and so your flow is gone. You cannot say anything because he is the judicial member topmost that time. And right now we are going to this. This is another fine case. Somebody asked me this other side, sir, my case has suddenly come. I didn't see it. I said, what is the case? He said, there's a condonation delay is there, and then then it is before Sharmaji. Therefore, Justice Sharma will issue notice only. Then they found the order the same, and then we have the issues have been deliberated, friends, and we hope that there is another bench will come. We hope our suggestions, not my suggestions, suggestions of all the learned senior advocates. Yes. Thank you, dear friends.